Hi, this is the Business Guy. Let's talk about transferring real estate privately so it doesn't appear in the public records. This means nobody knows about the transfer but you. In fact, there are two main ways to hide property title transfers, and I'll tell you my favorite and what's worked best for thousands of our clients. So first, we're going to talk about the different types of deeds and what each one does. We'll talk about how to hide property transfer from the public, and we'll talk about how to save thousands of dollars in transfer tax when you sell or transfer property. And if you're watching this on YouTube, please click the like button below so YouTube promotes this video. Thanks so much. And you can also click the subscribe button so that when more videos come out like this, you'll get notified. Okay, so if you've purchased property before, you likely generally know what a deed is and how it works. People use deeds to transfer property to another party, to another person, to multiple people, to companies such as LLCs, to living trusts, etc. So when you buy property, the deed goes to you. So what are the different types of deeds? They're typically called grant deeds, warranty deeds, or quitclaim deeds. What's the difference among these different types of deeds? Well, grant deeds contain two guarantees. First, the grantor states that the property has not been sold to anybody else. Secondly, it states the property is not burdened by encumbrances apart from those the seller has already disclosed to the buyer. That's a grant deed. Warranty deeds are used all over the United States, but are most common in the Midwest and Eastern states. They're very similar to grant deeds with one exception. Instead of two guarantees like the grant deeds we just covered, warranty deeds contain three. With a warranty deed, the grantor states that the property has not been sold to anybody else. Next, that they will defend and warrant the title against claims of all persons. And third, the grantor declares that the property is not burdened by any encumbrances apart from those issues about which the seller has already told the buyer. In essence, the grantor guarantees the grantee that the title is free of any defects that may affect the title, even if the defect was caused by a previous owner. And finally, quitclaim deeds are used to convey any interest in the property that the grantor might possess in the property. The grantor might be a legal owner or not. The deed makes no promise in that regard. So in essence, a quitclaim deed says, I'm not saying I have any ownership interest in the property, but whatever interest I do have, I give to you. Quitclaims are often used in divorce situations to deed a marital property from one spouse to another. Let's say a married person holds the title to a property and is the sole and separate owner. Say they acquired the property before marriage. The spouse who is not on title might be asked to sign a quitclaim deed to ensure they don't later try to lay claim to the property. So when we say the word deed here, we're referring to one of those three types of deeds that people use to transfer properties from one party to another. A deed is typically delivered to the county recorder's office in the county where the property is located. The seller signs the deed in front of a notary public, then the document is recorded either physically on a piece of paper, or in many counties, the document is submitted electronically. Doing so shows the world that you are the legal owner of the property. Now, once the deed is recorded, there are two ways we'll discuss here to transfer ownership privately. First, you can put the property into a land trust. That's our favorite way to transfer property. In fact, a land trust is a document that we draft that our clients use to own real estate privately. We've set up thousands of land trusts over the 30 years I've been in this business. Our research has shown us that land trusts are legal in all 50 states. Now, some states specifically name land trusts in their statutes, some don't. But there are also no laws that we know of that say you can or cannot wear red shoes. So not everything that we can or cannot do is written in the law book. Simple common law, on which most of our laws are based, allows for the use of trusts and has for centuries. And we've set up land trusts which have been successfully used in all 50 states and many foreign countries. Now, the cool thing is, most of the lenders will only lend to you if you hold the property in your own name. However, once you get your mortgage, the Garn Germain Depository Institutions Act allows you to put the property into a land trust without the lender calling the loan due. The property needs to be between 1 and 4 residential units, and you're the beneficiary of the trust. So step 1, call us and have us set up a land trust and a transfer deed. Step 2 is to have all of the relevant parties sign the land trust and the transfer deed in front of a notary public. Step 3 is to store the land trust in a safe place that you can access. You don't typically record the land trust, you keep that in a safe place at home. Step 4 is to record the transfer deed. This creates a public record that the trust/trustee now holds title of the property. Now, we also provide you with an additional important document called the Assignment of Beneficial Interest. Cutting through the technicalities, A beneficiary of a land trust essentially owns the property. Simply put, the beneficiary holds the rights to the benefits of the property that the trust holds. So if you are the beneficiary of the trust, you can assign your beneficial interest in the trust to someone else, such as your LLC, so that you have protection from lawsuits that originate from that property. Now, your personal residence and your investment properties fall into two separate tax categories. We would not assign your beneficial interest in a land trust to an LLC if that land trust owns your personal residence, as this could affect tax benefits that you enjoy in your primary dwelling. But with rental property, we routinely assign beneficial interest to LLCs as the tax benefits remain. Plus, you get the tremendous legal protection that the LLC can offer. Someone slips or falls or dies on the property and you have $500,000 of insurance, somebody could sue you for $3 to $4 million. The LLC can protect you from that lawsuit. So by assigning your interest in the property to an LLC, you do that privately with your assignment of beneficial interest in the land trust. So now you can show the trust with yourself as the beneficiary, and then when a lawsuit comes knocking, you can also show your assignment of beneficial interest document. This document shows that you assigned your beneficial interest in the trust to an LLC so that you have liability protection. Now, it's best practice to have your assignment of beneficial interest in the trust notarized as third-party proof that you assigned it on a certain date. In addition to privately transferring the property to a company or another person, a land trust can also protect you from paying expensive property transfer fees. I just read this morning, for example, an article about the Florida Department of Revenue. A high court ruling enabled the sellers to avoid the documentary stamp taxes by structuring real estate deals in company mergers and foreign land trusts. This strategy is often used to conceal the identity of buyers in high-end real estate deals. So not only can the land trust help you transfer property privately, it can also save you tons of money in transfer taxes by simply assigning the beneficial interest in the trust instead of recording the transfer in the public record. So if you want to transfer a $3 million property to another party in Miami-Dade County, as of this recording, the county would charge you $18,010 for a single-family home and $31,510 in fees for any other type of property, such as a duplex or commercial building. By using a land trust instead, the cost is absolutely zero. So the first way to transfer title privately is with a land trust. A second way to transfer title privately is with what we call a pocket deed. Now, I don't like doing it this way in most cases, but here's how it's done. Now, most people would think in order for the deed to be legally enforceable that you actually have to record it. When you notarize a deed to transfer a property, you can show evidence of the intent to transfer. How do we do that? The deed needs to be in writing and preferably notarized so that you have third-party proof that you didn't just do it yesterday. You'll typically have written on the deed the tax parcel number. I also like to write the street address on the deed so a normal person can read it. You can also write or attach a copy of the property legal description. In addition to that, you also need to have what is called delivery and acceptance. That is, the one to which the property is being transferred has received a copy of the deed. Now keep in mind, the only one who signs the deed is the person who transferred the property. The recipient doesn't need to sign anything in order to receive the property. So it'll say, for example, John Smith hereby conveys the following described property to the 123 Main Street Trust with XYZ LLC as trustee. Now the manager of XYZ LLC, the property title recipient in this case, doesn't sign it, just the grantor. The one giving the property away or selling the property is the one who signs it. So if it was your property before the transfer, that would be you. So when somebody records the deed, it lets the world know that the property is held by the trust/trustee and not John Smith anymore. If somebody, say the manager of Blue Sky LLC, doesn't record the deed, then the public records will still show John Smith as the owner of the property. So John Smith could then sell the property to Green Tree LLC. Say Green Tree pays for title insurance, and it still shows John Smith as the owner of the property. Meanwhile, John Smith moved to Costa Rica with all of the money from both buyers. And then the manager of Blue Sky LLC would have to fight like heck and spend tens of thousands of dollars in court to get the property. That's why we have a public recorder's office, to prevent this type of shenanigans from happening. In fact, I had a legal case in the state of Washington, and in that state, the unrecorded deed took precedent. I've seen other cases in California, which they call a race state, meaning whoever races down to the county recorders first wins. So that's the second way you can do it, and you can see why I like the land trust more than I like the pocket deed. But if you live in a state like Pennsylvania that charges you out the nose for transferring the property into a land trust, and that's the only state I know of that does, paying an extra $5,000 or $10,000 or $15,000 more after the fact and recording the deed that you have notarized 5 years ago might really make sense. And then a few states charge you for transferring the title to property directly into an LLC, and many don't if you own the property before and you're also the owner of the LLC. So some terrible lawsuit could strike that originated on the property that could wipe you out, and you didn't want to record the transfer deed because you wanted to save the money on the transfer tax, delaying paying $10,000 might possibly make sense in a case like that. And then record it later, because it's a heck of a lot better to pay 10 grand than face a lawsuit that could take $500,000 out of your pocket. You'd be happy to pay the 10K, and instead of wishing you'd transferred it way back when, you have a notarized deed that you can record quickly. Let's say you get into a lawsuit. You hurry up and record that pocket deed before the lawsuit freezes the title of the property. Somebody might ask, isn't it a fraudulent conveyance or fraudulent transfer to record the deed after you're sued? And the answer is no. Keep in mind, you notarized the deed 5 years ago. You have evidence that the property was transferred 5 years back. So in those scenarios where you're transferring it to an entity you control, and you want to avoid the transfer tax, you still have an asset protection device that you can deploy when you need it. Now just keep in mind that you not only have to have had the deed notarized, but you also must have kept your LLC in good standing throughout the process by paying the annual government and registered agent fees. Now keep in mind, there are over 3,006 counties in the US. They all have their little quirks, and we don't know all of them. So before doing any of this, get legal advice for your specific situation from an attorney. And we do have attorneys on our full-time staff here that you can talk to if you want to set up a land trust or LLC. I hope you found this information valuable. Please click like, subscribe, share this video. Thanks for watching. This is The Business Guy.